The DNI's semi-annual assessment of Section 702 disclosed illegal queries conducted in 2019 to 2020, quote, using only the name of a U.S. congressman. The FISA court disclosed two particularly egregious searches from 2022. In June of 2022, an analyst conducted 4 queries of 702 information using the last names of a U.S. senator and of a state senator without further limitation. On October 25, 2022, a staff's operations specialist ran a query using the Social Security number of a state judge who had, quote, complained to FBI about alleged civil rights violations perpetrated by a municipal chief of police, close quote. Were the FBI employees who conducted those illegal searches terminated, or did they have their security clearances stripped? Yes or no?
Again, I don't know that I can speak to specific instances, but what I can tell you, and I think this is important to this exchange, is that all of the instances you just listed off all involve conduct that occurred before the reforms that we put in place.
Before the reforms you put in place, reforms, the text of which we don't even have access to. Reforms that you've put in place. I've been on this committee for 13 years. During the entirety of those 13 years, I've expressed concerns to FBI directors appointed by presidents of both political parties and 3 different presidential administrations. Every darn one of them has told me the same thing. Don't worry about it. We've got this taken care of. We've got new procedures. It's going to be different now. It's never different. You haven't changed. And you keep referring to these policies, these new procedures. We haven't seen that. We're not even allowed to have access to it. And we have absolutely no reason to trust you because you haven't behaved in a manner that's trustworthy. You can't even, as we sit here, tell me that people who intentionally, knowingly, deliberately violated the civil rights of American citizens, that they were fired or that they had their security clearance stripped. Now, in 2022, FBI and other agencies searched Americans' communications over 200,000 times, only 16 of which were evidence of a crime-only searches that returned information. I'd like to ask you to give a yes or a no answer to these questions. Were the 3 related batch queries consisting of over 23,000 separate queries relating to the events of January 6th, were those evidence of a crime-only queries, yes or no?
I don't know the answer to that.
The answer is no. I do know the answer. The answer is no. Were the 141 queries for the activists arrested in connection with the George Floyd protests here in Washington, D.C., evidence of a crime-only queries?
Those were non-compliant queries. And again, they all predate the reforms that we've put in place, which
echo other reforms that other FBI directors have told me about every darn year.
If
How about
I may,
the 19,000 donors to a political campaign? The answer there is no. What about the query for a sitting member of Congress? The answer there is no. What about the query involving a U.S. senator, which for all we know could be any one of us? The answer is no. And so what does that tell me? Well, what I'm hearing and what these data points all point to is that a warrant requirement or prohibition relating to, quote unquote, evidence of a crime-only queries would not have been something that would have prevented any of the most egregious examples of the abuse that we've seen under Section 702. So the FBI is already required to obtain a court order in some circumstances before accessing the contents of Americans' communications in the context of 702. They're already required for that in some circumstances. Since 2018, how many times has that requirement been triggered, according to government reporting? Do you know?
Are you talking about the so-called F2?
Yes.
How many times has it been triggered?
Yes.
I think there have been 2 instances where I think is maybe the number.
103 times it's been triggered. And out of those 103 identified times, the FBI should have obtained a court order. How many times did the FBI actually obtain one? Do you know?
That, I think the answer is none.
0. So you're telling me that the FBI has completely ignored the limited court order requirement that it's already subjected to. You have the audacity to come here, and you told us that adding a warrant requirement to 702, even for queries involving U.S. persons on U.S. soil, that would amount to some sort of unilateral disarmament. You have a lot of gall, sir. This is disgraceful. The Fourth Amendment requires more than that, and you know it. I know every single time for centuries, even prior to the founding of this country, there were similar protections built into the laws of the United Kingdom before we became a country. Even then, the government was making the same darn argument you're making today, which is it's too hard. This would make it hard for the government. It's why we have a Constitution, sir, and you must comply with it.